Welcome to The Explainer. Today, we're not just looking at one of Australia's most chilling criminal sagas. We're actually using it to build a barrister's toolkit. We're going to break down the landmark evidence rulings in the trials of Peter Dupas, and this is absolutely essential knowledge for anyone staring down the barrel of the bar exam.
Okay, here's how we're going to tackle this. First, we'll get the facts straight with the Dupas case files. Then, we'll get into the nitty-gritty, how you prove a signature crime, what to do when evidence is flat-out dangerous, the chaos of trial by media, and then finally, we'll tie it all together.
So, first things first. To really get a grip on these legal principles, you have to understand the man at the center of it all, Peter Dupas. His crimes, they created this perfect storm for testing the absolute limits of our evidence laws.
And this is really the heart of the matter, isn't it? When the media and the public have already decided someone's guilty, the rules of evidence are pretty much the only thing standing between a fair trial and, well, a public lynching. This is the tightrope every single barrister has to walk.
So Dupas was eventually convicted for 3 separate, incredibly brutal murders of women. And the shocking nature of these crimes, especially the bizarre and frankly horrifying post-mortem mutilations, it just created this atmosphere of intense public fear and media scrutiny that put enormous, and I mean enormous, pressure on the justice system. All right, let's get into our first core lesson for the bar exam, and this one comes straight out of the Margaret Maher trial. The big question was this: can you use the facts of one horrific murder to help prove who the killer was in a different murder?
And this brings us to the doctrine of similar fact evidence, sometimes called propensity evidence. The prosecution desperately wanted to bring in evidence from the Patterson murder during the Maher trial. Their argument? The killer's method was so unique, so out there, it could only point to one person.
Now, the court had a really difficult puzzle on its hands here. On one hand, you have this chillingly specific act, the post-mortem removal of breasts, which everyone agreed was a rare and unusual occurrence. But on the other hand, you've got pretty big differences in the cause of death, the specifics of the mutilation, and where the bodies were even found.
And this brings us right to the legal test you have to know. The court looked back to the House of Lords and confirmed that for this kind of evidence to get in, it can't just show that a person has a general tendency to be violent. No way. It has to reveal a signature, something so distinctive it compellingly points to the same person. So the whole thing came down to this critical balancing act. The judge decided that the evidence's probative value, its power to prove the identity of the person who committed this incredibly rare act, was so high that it actually outweighed the extreme prejudice of the jury knowing Dupas was already a convicted murderer. The jury was then asked to perform what one lawyer called gold medal mental gymnastics. They could use the evidence to say it's the same mutilator, but they couldn't use it to say, well, because he murdered once, he must have done it again.
Okay, on to the Halvages trial. This one is a textbook case, a gold mine for your exams really, on how to handle 2 notoriously unreliable but often very powerful types of evidence: eyewitnesses and jailhouse informants.
Let's start with eyewitness testimony. The law has understood for a very long time that a witness can be completely honest and completely mistaken. To guard against that, the High Court in a case called Domican created a mandatory warning a judge has to give about the inherent dangers of identification evidence.
And here's the key thing to remember for your exams. A generic warning just won't cut it. The judge can't just tick a box. They have to actively pull apart the evidence for the jury, point out the specific weaknesses, and do it with the full authority of their office. In one of Dupas's trials, the appeal court actually found the judge's warning was too general and didn't properly highlight the frailties in what the witnesses said. Now, the prosecution's case also relied heavily on a prison informer, the disgraced lawyer Andrew Fraser. He claimed Dupas had admitted things to him while they were in jail, even acting out a chilling pantomime of the killing. The courts see this kind of evidence as inherently suspect, and for pretty obvious reasons, right? The informers are often criminals themselves, they almost always have a powerful motive to lie, maybe to get a reduced sentence or reward, and there's hardly ever a way to back up their story. This means the judge has to give another specific warning, a pullet warning, that tells the jury it's dangerous to convict based on this kind of evidence alone.
All right, let's talk about the massive hurdle that hung over all of the Dupas trials: a relentless, hostile media campaign that basically put him on trial long before he ever stepped foot in a courtroom. The pre-trial publicity was just overwhelming. For years, Dupas was labeled a monster and a serial killer in newspapers and on TV. This created this huge risk that it would be literally impossible to find a jury that hadn't already been swayed.
So this creates a fundamental conflict, a real tug-of-war for the justice system. On one side, you've got the accuser's right to be judged only on the evidence heard in court. But on the other, you have the community's right to see offenders brought to trial. You just can't let the media make someone immune from prosecution.
And this quote from the High Court case of Glennon really says it all. The courts refused to permanently stop the proceedings, arguing that the system simply cannot be held hostage by the media. The answer isn't to cancel the trial. The answer is to trust the system, to trust in strong judicial directions and in the jury's oath to decide the case only on the evidence they hear in that courtroom.
So, after going through all these harrowing cases and these complex rules, what is the big takeaway? What does all this mean for you as an aspiring barrister getting ready for the bar?
Well, it really all boils down to this one fundamental skill. Almost every major evidence battle in the Dupas trials came down to arguing the delicate balance between an item of evidence's probative value and its prejudicial effect. Mastering that argument, well, that's the art of advocacy.
And these cases are the ultimate proof that evidence law isn't just some dry academic subject you need to pass an exam. These rules are the firewalls. They are the essential safeguards that protect the presumption of innocence and make sure that even when the public is screaming for a conviction, a trial is decided by law, not by emotion.
And that leaves us with one final question, one that was taken directly from the arguments in the case itself. We ask our juries to perform these incredible feats of mental discipline, right? To ignore their prejudices, to surgically separate pieces of evidence, to follow really complex legal directions. It just highlights the immense responsibility we place on them. And, more importantly, on you, the future barristers who have to guide them through that evidence to reach a just and lawful verdict.